Welcome back to Autism Live. We are joined right now by the fabulous Bonnie Yates from the law firm of Hirji & Chow. She's a special education attorney, and she's here to talk about topics that help us to know how to better represent our children and get more representation so we can get more help. Bonnie, welcome, and tell us a little bit about Hirji & Chow.
Hi, Shannon. Thank you for having me. Hirji & Chow is a six-attorney special education firm. We're based in Culver City. We do special education, regional center services, disability discrimination, which encompasses something we're going to be talking about soon, injuries to students at school as well, even though those are personal injury type cases in an aspect. And we also do higher education, which would be helping students that are discriminated against in college. We are answering your questions on the air according to California and federal law, because I'm licensed in California and IDEA is a federal statute. If you're in another state or you have a specific legal problem, you need a specific consultation with an attorney that can focus on your singular problem. Here, we're basically talking to you about your rights, and we're not really giving you specific legal advice.
Okay, great disclaimer. So last week we had been talking about private placement. Was there anything that you wanted to add from that before we move on to school injury?
I did want to just read you all some citations that I forgot about on the air, and I think you can use it as a little test to test your understanding and see if you understand this now or you have more questions. So when a parent believes that a public educational placement is denying her child FAPE, the parent may choose to remove the child to a private placement. However, parents who remove the child do so at their own financial risk. That's two cases, WG versus Board of Trustees of Target Range School District and also Florence County School District versus Carter. This means that the parents may have to pay the full cost of the private placement. A parent's dissatisfaction with the district's offer of FAPE does not create the basis for the district to fund a private placement unless the district fails to offer the student a FAPE. So we talked about that last time, how you would show that the district had failed to offer FAPE and how your student, what data you would need to show your student made progress in the private placement. Another thing that comes up for students that are in private placements is that the district still has an obligation to hold an annual IEP and revise the student's IEP, and that's not something that I mentioned, but that can be important because you want to make sure that your student has an IEP that he or she can take with him to college that would list what his accommodations were. And it's also important that the district be required to continue on an annual basis trying to provide FAPE to the student. So that was something I didn't say last time.
Okay, so point of clarification. So even though your student is now at another school, their home school has to hold an IEP for them every year?
They do.
Okay, didn't know that.
Yeah.
What if they fail to do that?
Sorry?
If they fail to?
That can cause problems for them. I mean, I had a reimbursement case where we knew we were going to be looking for a lot of money, and we knew sorry about the noises in the background with the computer. The most we could get in California was 2 years of reimbursement. So we gave the notice almost as soon as the student was placed. And because it was LA Unified, we were fairly confident that this notice would go into a black hole. You'll recall my discussion last week about strategic considerations about where to give the notice. And sure enough, it did go into a black hole. And so right before the statute of limitations ran, I filed for due process. By then, the family had 2 years of reimbursements that they were owed for the private school. And when the district got to the initial meeting, they were mad that I hadn't done more to try to get a meeting with them, but I had done enough. I'd given the notice, and then a couple times hence I'd followed up, and nobody ever followed up with me, and that was that. So they have a duty annually to have an IEP meeting. And part of the reason they're supposed to is because I think that it is a fail-safe in terms of making sure that people don't just disappear. I also want to say, and I didn't say this last time, that when the notice requirement is fairly new, it's something that's come up within the last 15 years or so, maybe 20 years. It used to be the case that people would just take their kids out of school and they'd disappear for 3 years, which was the statute of limitations then in California before 2004. And then they weren't even required to give notice. And so the public schools were getting surprised because they would have somebody show up with 3 years worth of claims, and it was like, wow, we didn't even notice you were gone.
Wow.
So that's another component of this. Anyway, it's also a requirement in California, in my view, that if you have a private school placement, the district ought to try to get the private school representatives to participate in the IEP meeting. That's just a little goodie about that for you all. Reimbursement not required if the lead educational agency makes FAPE available. Private school tuition reimbursement is available as a remedy under the IDEA where a court or hearing officer finds the public agency did not make FAPE available to the student in a timely manner prior to the private enrollment, and the private placement is determined to be appropriate. So you can see there that the courts are always looking at the two questions. One was FAPE offered, and two was the private placement appropriate, and that's what we talked about last time. And the specific cases go through and they look at whether or not there's progress data. So I mean, here's a case where out of the District of Columbia, a high schooler's academic and social success in his unilateral private placement undermined the District of Columbia's claim that the private school did not meet IDEA standards for purposes of the parent's reimbursement request. So there we're cycling back to, if you have academic and social progress in excess, in significant excess of what you had in public school, you're probably on your way to getting reimbursed. So there has to be no FAPE and there has to be progress. What else did I want to tell you? Well, that might actually be enough. I think those were the main other points I wanted to make about private school placements, unless you have any questions.
Hey, thanks for watching Autism Live. To subscribe, click here. And if you'd like to check out some more of our videos, click here.